Rule 15 Motions, Section 1 Motion Defined. A motion is an application for relief other than by a pleading. Section 2 Motions must be in writing. All motions shall be in writing except those made in open court or in the course of a hearing or trial. A motion made in open court or in the course of a hearing or trial should immediately be resolved in open court after the adverse party is given the opportunity to argue his or her opposition thereto. When a motion is based on facts not appearing on record, the court may hear the matter on affidavits or depositions presented by the respective parties, but the court may direct that the matter be heard wholly or partly on oral testimony or depositions. Section 3 Contents. A motion shall state the relief sought to be obtained and the grounds upon which it is based, and if required by these rules or necessary to prove facts alleged therein, shall be accompanied by supporting affidavits and other papers. Section 4 Non-litigious motions. Motions which the court may act upon without prejudicing the rights of adverse parties are non-litigious motions. These motions include letter A. Motion for the issuance of an alias summons. B. Motion for extension to file answer. C. Motion for postponement. D. Motion for the issuance of a writ of execution. E. Motion for the issuance of an alias writ of execution. F. Motion for the issuance of a writ of possession. G. Motion for the issuance of an order directing the sheriff to execute the final certificate of sale, and H. Other similar motions. These motions shall not be set for hearing and shall be resolved by the court within 5 calendar days from receipt thereof. Section 5 Litigious motions. A. Litigious motions include 1. Motion for bill of particulars. 2. Motion to dismiss. 3. Motion for new trial. 4. Motion for reconsideration. 5. Motion for execution pending appeal. 6. Motion to amend after a responsive pleading has been filed. 7. Motion to cancel statutory lien. 8. Motion for an order to break in or for a writ of demolition. 9. Motion for intervention. 10. Motion for judgment on the pleadings. 11. Motion for summary judgment. 12. Demurrer to evidence. 13. Motion to declare defendant in default. And 14. Other similar motions. B. All motions shall be served by personal service, accredited private courier, or registered mail or electronic means so as to ensure their receipt by the other party. C. The opposing party shall file his or her opposition to a litigious motion within 5 calendar days from receipt thereof. No other submissions shall be considered by the court in the resolution of the motion. The motion shall be resolved by the court within 15 calendar days from its receipt of the opposition thereto, or upon expiration of the period to file such opposition. Section 6 Notice of hearing on litigious motions. Discretionary. The court may, in the exercise of its discretion, and if deemed necessary for its resolution, call a hearing on the motion. The notice of hearing shall be addressed to all parties concerned and shall specify the time and date of the hearing. Section 7 Proof of service necessary. No written motion shall be acted upon by the court without proof of service thereof, pursuant to Section 5B hereof. Section 8 Motion day, except for motions requiring immediate action where the court decides to conduct hearing on a litigious motion, the same shall be set on a Friday. Section 9 Omnibus motion. Subject to the provisions of Section 1 of Rule 9, a motion attacking a pleading, order, judgment, or proceeding shall include all objections then available, and all objections not so included shall be deemed waived. Section 10 Motion for leave. A motion for leave to file a pleading or motion shall be accompanied by the pleading or motion sought to be admitted. Section 11 Form. The rules applicable to pleadings shall apply to written motions so far as concerns caption, designation, signature, and other matters of form. Section 12 Prohibited motions. The following motions shall not be allowed. Letter A. Motion to dismiss, except on the following grounds. 1. That the court has no jurisdiction over the subject matter of the claim. 2. That there is another action pending between the same parties for the same cause. And 3. That the cause of action is barred by a prior judgment or by the statute of limitations. B. Motion to hear affirmative defenses. C. Motion for reconsideration of the court's action on the affirmative defenses. D. Motion to suspend proceedings without a temporary restraining order or injunction issued by a higher court. E. Motion for extension of time to file pleadings, affidavits, or any other papers except a motion for extension to file an answer as provided by Section 11, Rule 11. And F. Motion for postponement intended for delay except if it is based on acts of God, force majeure, or physical inability of the witness to appear and testify. If the motion is granted based on such exceptions, the moving party shall be warned that the presentation of its evidence must still be terminated on the dates previously agreed upon. A motion for postponement, whether written or oral, shall at all times be accompanied by the original official receipt from the office of the clerk of court, evidencing payment of the postponement fee under Section 21B, Rule 141, to be submitted either at the time of the filing of said motion or not later than the next hearing date. The clerk of court shall not accept the motion unless accompanied by the original receipt. Section 13. Dismissal with prejudice. Subject to the right of appeal, an order granting a motion to dismiss on affirmative defense that the cause of action is barred by a prior judgment or by the statute of limitations, that the claim or demand set forth in the plaintiff's pleading has been paid, waived, abandoned, or otherwise extinguished, or that the claim on which the action is founded is unenforceable under the provisions of the statute of frauds, shall bar the refiling of the same action or claim. Rule 16. Motion to dismiss provisions either deleted or transposed. Rule 17. Dismissal of actions. Section 1. Dismissal upon notice by plaintiff. A complaint may be dismissed by the plaintiff by filing a notice of dismissal at any time before service of the answer or of a motion for summary judgment. Upon such notice being filed, the court shall issue an order confirming the dismissal. Unless otherwise stated in the notice, the dismissal is without prejudice, except that the notice operates as an adjudication upon the merits when filed by a plaintiff who has once dismissed in a competent court an action based on or including the same claim. Section 2. Dismissal upon motion of plaintiff. Except as provided in the preceding section, a complaint shall not be dismissed at the plaintiff's instance, save upon approval of the court and upon such terms and conditions as the court deems proper. If a counterclaim has been pleaded by a defendant prior to the service upon him or her of the plaintiff's motion for dismissal, the dismissal shall be limited to the complaint. The dismissal shall be without prejudice to the right of the defendant to prosecute his or her counterclaim in a separate action unless within 15 calendar days from notice of the motion he or she manifests his or her preference to have his or her counterclaim resolved in the same action. Unless otherwise specified in the order, a dismissal under this paragraph shall be without prejudice. A class suit shall not be dismissed or compromised without the approval of the court. Section 3. Dismissal due to fault of plaintiff. If for not justifiable cause, the plaintiff fails to appear on the date of the presentation of his or her evidence in chief on the complaint, or to prosecute his or her action for an unreasonable length of time, or to comply with these rules or any order of the court, the complaint may be dismissed upon motion of the defendant or upon the court's own motion, without prejudice to the right of the defendant to prosecute his or her counterclaim in the same or in a separate action. This dismissal shall have the effect of an adjudication upon the merits unless otherwise declared by the court. Section 4. Dismissal of counterclaim, cross-claim, or third-party complaint. The provisions of this rule shall apply to the dismissal of any counterclaim, cross-claim, or third-party complaint. A voluntary dismissal by the claimant by notice, as in Section 1 of this rule, shall be made before a responsive pleading or a motion for summary judgment is served, or if there is none, before the introduction of evidence at the trial or hearing. Rule 18. Pre-trial. Section 1. When conducted. After the last responsive pleading has been served and filed, the branch clerk of court shall issue within 5 calendar days from filing a notice of pre-trial, which shall be set not later than 60 calendar days from the filing of the last responsive pleading. Section 2. Nature and purpose. The pre-trial is mandatory and should be terminated promptly. The court shall consider A. the possibility of an amicable settlement or of a submission to alternative modes of dispute resolution, B. the simplification of the issues, C. The possibility of obtaining stipulations or admissions of facts and of documents to avoid unnecessary proof. D. The limitation of the number and identification of witnesses and the setting of trial dates. E. The advisability of a preliminary reference of issues to a commissioner. F. The propriety of rendering judgment on the pleadings or of summary judgment or of dismissing the action should the valid ground therefore be found to exist. G. The requirement for the parties to 1. Mark their respective evidence, if not yet marked, in the judicial affidavits of their witnesses. 2. Examine and make comparisons of the adverse parties' evidence vis-a-vis the copies to be marked. 3. Manifest for the record stipulations regarding the faithfulness of the reproductions and the genuineness and due execution of the adverse parties' evidence. 4. Reserve evidence not available at the pre-trial but only in the following manner. 1. For testimonial evidence by giving the name or position and the nature of the testimony of the proposed witness. 2. For documentary evidence and other object evidence by giving a particular description of the evidence. No reservation shall be allowed if not made in the manner described above. H. Such other matters as may aid in the prompt disposition of the action. The failure without just cause of a party and counsel to appear during pre-trial despite notice shall result in a waiver of any objections to the faithfulness of the reproduction marked or their genuineness and due execution. The failure without just cause of a party and or counsel to bring the evidence required shall be deemed a waiver of the presentation of such evidence. The branch clerk of court shall prepare the minutes of the pretrial, which shall have the following format. See prescribed form 2A. Section 3. Notice of pretrial. The notice of pretrial shall include the dates respectively set for A. Pretrial, B. Court-annexed mediation, and C. Judicial dispute resolution if necessary. The notice of pretrial shall be served on counsel or on the party if he or she has no counsel. The counsel served with such notice is charged with the duty of notifying the party represented by him or her. Non-appearance at any of the foregoing settings shall be deemed as non-appearance at the pretrial and shall merit the same sanctions under Section 5 hereof. Section 4. Appearance of parties. It shall be the duty of the parties and their counsel to appear at the pre-trial, court-annexed mediation, and judicial dispute resolution if necessary. The non-appearance of a party and counsel may be excused only for acts of God, force majeure, or duly substantiated physical inability. A representative may appear on behalf of a party but must be fully authorized in writing to enter into an amicable settlement, to submit to alternative modes of dispute resolution, and to enter into stipulations or admissions of facts and documents. Section 5. Effect of failure to appear. When duly notified, the failure of the plaintiff and counsel to appear without valid cause when so required, pursuant to the next preceding section, shall cause the dismissal of the action. The dismissal shall be with prejudice unless otherwise ordered by the court. A similar failure on the party of the defendant and counsel shall be caused to allow the plaintiff to present his or her evidence ex parte within 10 calendar days from termination of the pre-trial, and the court to render judgment on the basis of the evidence offered. Section 6. Pre-trial brief. The parties shall file with the court and serve on the adverse party in such manner as shall ensure the receipt thereof at least 3 calendar days before the date of the pre-trial, the respective pre-trial briefs, which shall contain, among others, A. A concise statement of the case and the reliefs prayed for. B. A summary of admitted facts and proposed stipulation of facts. C. The main factual and legal issues to be tried or resolved. D. The propriety of referral of factual issues to commissioners. E. The documents or other object evidence to be marked stating the purpose thereof. F. The names of the witnesses and the summary of the respective testimonies. And G. A brief statement of points of law and citation of authorities. Failure to file the pre-trial brief shall have the same effect as failure to appear at the pre-trial. Section 7. Pre-trial order. Upon termination of the pre-trial, the court shall issue an order within 10 calendar days which shall recite in detail the matters taken up. The order shall include A. An enumeration of the admitted facts. B. The minutes of the pre-trial conference. C. The legal and factual issues to be tried. The Letter D, the applicable law, rules, and jurisprudence. E, the evidence marked. F, the specific trial dates for continuous trial which shall be within the period provided by the rules. G, the case flow chart to be determined by the court which shall contain the different stages of the proceedings up to the promulgation of the decision and the use of time frames for each stage in setting the trial dates. H, a statement that the one-day examination of witness rule and most important witness rule under AM number 03-1-09-SC. Guidelines for pretrial shall be strictly followed. And I, a statement that the court shall render judgment on the pleading or summary judgment as the case may be. The direct testimony of witness for the plaintiff shall be in the form of judicial affidavits. After the identification of such affidavits, cross-examination shall proceed immediately. Postponement of presentation of the parties' witnesses at a scheduled date is prohibited, except if it is based on acts of God, force majeure, or duly substantiated physical inability of the witness to appear and testify. The party who caused the postponement is warned that the presentation of its evidence must still be terminated within the remaining days previously agreed upon. Should the opposing party fail to appear without valid cause stated in the next preceding paragraph, the presentation of the scheduled witness will proceed with the absent party being deemed to have waived the right to interpose objection and conduct cross-examination. The contents of the pretrial order shall control the subsequent proceedings unless modified before trial to prevent manifest injustice. Section 8, Court-annexed mediation. After pretrial and after issues are joined, the court shall refer the parties for mandatory court-annexed mediation. The period for court-annexed mediation shall not exceed 30 calendar days without further extension. Section 9, Judicial dispute resolution. Only if the judge of the court to which the case was originally raffled is convinced that settlement is still possible, the case may be referred to another court for judicial dispute resolution. The judicial dispute resolution shall be conducted within a non-extendable period of 15 calendar days from notice of failure of the court-annexed mediation. If judicial dispute resolution fails, trial before the original court shall proceed on the dates agreed upon. All proceedings during the court-annexed mediation and the judicial dispute resolution shall be confidential. Section 10, Judgment after pretrial. Should there be no more controverted facts or no more genuine issue as to any material fact or an absence of any issue, or should the answer fail to tender an issue, the court shall, without prejudice to a party moving for judgment on the pleadings under Rule 34 or summary judgment under Rule 35, motu proprio, include in the pretrial order that the case be submitted for summary judgment or judgment on the pleadings without need of possession papers or memoranda. In such cases, judgment shall be rendered within 90 calendar days from the termination of the pretrial. The order of the court to submit the case for judgment pursuant to this rule shall not be subject to appeal or certiorari. Rule 19, Intervention. Section 1, who may intervene? A person who has a legal interest in the matter in litigation or in the success of either of the parties, or an interest against both, or is so situated as to be adversely affected by a distribution or other disposition of property in the custody of the court or of an officer thereof, may, with leave of court, be allowed to intervene in the action. The court shall consider whether or not the intervention will unduly delay or prejudice the adjudication of the rights of the original parties, and whether or not the intervener's rights may be fully protected in a separate proceeding. Section 2, Time to intervene. The motion to intervene may be filed at any time before rendition of judgment by the trial court. A copy of the pleading in intervention shall be attached to the motion and served on the original parties. Section 3, Pleadings in intervention. The intervener shall file a complaint in intervention if he or she asserts a claim against either or all of the original parties, or an answer in intervention if he or she unites with the defending party in resisting a claim against the latter. Section 4, Answer to complaint in intervention. The answer to the complaint in intervention shall be filed within 15 calendar days from notice of the order admitting the same, unless a different period is fixed by the court. Rule 20, Calendar of Cases. Section 1, Calendar of Cases. The clerk of court, under the direct supervision of the judge, shall keep a calendar of cases for pre-trial. For trial, those whose trials were adjourned or postponed, and those with motions to set for hearing. Preference shall be given to habeas corpus cases, election cases, special civil actions, and those so required by law. Section 2, Assignment of Cases. The assignment of cases to be different branches of a court shall be done exclusively by raffle. The assignment shall be done in open session, of which adequate notice shall be given so as to afford interested parties the opportunity to be present. Rule 21, Subpoena. Section 1, Subpoena and Subpoena duces tecum. Subpoena is a process directed to a person requiring him or her to attend and to testify at the hearing or the trial of an action or at any investigation conducted by competent authority or for the taking of his or her deposition. It may also require him or her to bring with him or her any books, documents, or other things under his or her control, in which case it is called a subpoena duces tecum. Section 2. By whom issued? The subpoena may be issued by letter A, the court before whom the witness is required to attend, B, the court of the place where the deposition is to be taken, C, the officer or body authorized by law to do so in connection with investigations conducted by said officer or body, or D, any justice of the Supreme Court or the Court of Appeals in any case or investigation pending within the Philippines. When application for a subpoena to a prisoner is made, the judge or officer shall examine and study carefully such application to determine whether the same is made for a valid purpose. No prisoner sentenced to death, reclusion perpetua, or life imprisonment and who is confined in any penal institution shall be brought outside the said penal institution for appearance or attendance in any court unless authorized by the Supreme Court. Section 3. Form and contents. A subpoena shall state the name of the court and the title of the action or investigation, shall be directed to the person whose attendance is required, and in the cases of a subpoena duces tecum, it shall also contain a reasonable description of the books, documents, or things demanded, which must appear to the court prima facie relevant. Section 4. Quashing a subpoena. The court may quash a subpoena duces tecum upon motion promptly made and in any event at or before the time specified therein if it is unreasonable and oppressive, or the relevancy of the books, documents, or things does not appear, or if the person in whose behalf subpoena is issued fails to advance the reasonable cost of the production thereof. The court may quash a subpoena ad testificandum on the ground that the witness is not bound thereby. In either case, a subpoena may be quashed on the ground that the witness fees and kilometrage allowed by these rules were not tendered when the subpoena was served. Section 5. Subpoena for depositions. Proof of service of a notice to take a deposition as provided in Section 15 and 25 of Rule 23 shall constitute sufficient authorization for the issuance of subpoenas for the person named in said notice by the clerk of court of the place in which the deposition is to be taken. The clerk shall not, however, issue a subpoena duces tecum to any such person without an order of the court. Section 6. Service. Service of subpoena shall be made in the same manner as personal or substituted service of summons. The original shall be exhibited and a copy thereof delivered to the person on whom it is served. The service must be made so as to allow the witness a reasonable time for preparation and travel to the place of attendance. Costs for court attendance and the production of documents and other materials subject of the subpoena shall be tendered or charged accordingly. Section 7. Personal appearance in court. A person present in court before a judicial officer may be required to testify as if he or she were in attendance upon a subpoena issued by such court or officer. Section 8. Compelling attendance. In case of failure of a witness to attend the court or judge issuing the subpoena upon proof of the service thereof, and of failure of the witness, may issue a warrant to the sheriff of the province or his or her deputy to arrest the witness and bring him or her before the court or officer where his or her attendance is required, and the cost of such warrant and seizure of such witness shall be paid by the witness if the court issuing it shall determine that his or her failure to answer the subpoena was willful and without just cause. Section 9. Contempt. Failure by any person without adequate cause to obey a subpoena served upon him or her shall be deemed a contempt of the court from which the subpoena is issued. If the subpoena was not issued by a court, the disobedience thereto shall be punished in accordance with the applicable law or rule. Section 10. Exceptions. The provisions of Sections 8 and 9 of this rule shall not apply to a witness who resides more than 100 kilometers from his or her residence to the place where he or she is to testify by the ordinary course of travel, or to a detention prisoner if no permission of the court in which his or her case is pending was obtained. Rule 22. Computation of time. Section 1. How to compute time. In computing any period of time prescribed or allowed by these rules, or by order of the court, or by any applicable statute, the day of the act or event from which the designated period of time begins to run is to be excluded, and the date of performance included. If the last day of the period is thus computed falls on a Saturday, a Sunday, or a legal holiday in the place where the court sits, the time shall not run until the next working day. Section 2, effect of interruption. Should an act be done which effectively interrupts the running of the period, the allowable period after such interruption shall start to run on the day after notice of the cessation of the cause thereof. The day of the act that caused the interruption shall be excluded in the computation of the period.